Now to a story where a 2-month-old child has died. A local man and woman are facing charges in the death of the 2-month-old, and it all happened in September of 2024. Leslie Delaspore spoke to the prosecutor in the case. Leslie, what did they have to say?
Yeah, Rashi, that's right. I was in court this morning, and the father is facing capital murder charges, and the mother is facing charges of injury to a child. But here's a quick recap of what happened in court. Now, 27-year-old Deari Olston came before a judge today alongside his attorney to discuss his bond and conditions. The prosecution went over the probable cause and read details about the case, such as the child's injuries, findings from a CPS investigation, questionable text messages between the parents, and deleted search history from the father's phone. Now, the judge set a bond at $2 million for the dad, and he was told he cannot have any contact with children, including his older child, who was a toddler. Now, as far as the mom, her bond was set at $250,000, and she did not make an appearance in the courtroom, but her attorney was present. And we did speak with the prosecutor after.
Let's go back to where this story begins. But before we do, take a moment to like this video, share it with someone who needs to hear it, and subscribe if you believe stories like this deserve to be told. Don't forget to tap the notification bell, because when we tell these stories, we speak up for the ones who can't. On the evening of Sunday, September 8th, 2024, emergency personnel at a Houston area hospital received a critically ill infant, just 2 months old. He was limp, unresponsive, and struggling to breathe. Medical staff immediately knew something was very wrong. They rushed the baby into emergency care. Tests showed a severe brain bleed, a skull fracture, and retinal hemorrhaging, internal bleeding behind the eyes, often a red flag for trauma in non-mobile infants. A trauma consult was ordered the very next morning, September 9th, when a pediatric specialist was called to assess what they believed could be signs of abuse. The child's condition did not improve. In fact, it worsened. Medical teams noted he was showing no signs of brain activity. Machines were doing the work of his tiny lungs. Monitors beeped steadily in the background, but the child was slipping away. By the time the official declaration came, it was 3 days later. On September 11th, 2024, the baby was pronounced dead. His name was Zane Olston. At that point, the Harris County Medical Examiner's Office took over. An autopsy would reveal what doctors suspected, that his injuries were not from illness or a birth condition. They were from force, repeated force. But back on the night of September 8th, before anyone outside that household knew what was unfolding, someone inside had already reached for their phone, and they typed questions no parent should ever have to ask. 2-month-old baby hard to wake up. What happens if your 2-month-old doesn't have a pulse? Does infant CPR really work? Will you go to jail if you find your child unresponsive? My 2-month-old died. Is anyone getting charged? The timestamps showed these searches were made well before 911 was ever called. Court documents later revealed that a full 39 minutes passed between the first search and the actual emergency call. By then, it was too late. When first responders arrived at the family's residence on Main Street, they encountered a scene that raised immediate questions. The baby was taken from the apartment to the hospital. His injuries were already extensive. Investigators began to dig into medical records, phone data, prior CPS involvement. But one thing was already clear. This baby had been hurt before. And on September 11th, the bruises, fractures, and brain trauma added up to one word: homicide. What's your first reaction to this timeline? Does the delay in calling 911 change how you view the case? 2 months of life. A timeline measured in medical charts. He was born on July 6, 2024, in Harris County, Texas. A baby boy just over 7 pounds. His name was Zane Olston. For many infants, the first 2 months of life are filled with love, growth, and endless little milestones. The first smile, the first coo, the comfort of being held close. But for Zane, those first weeks were not marked by lullabies or warm blankets. His short life unfolded under the close watch of hospitals, caseworkers, and emergency rooms. Court documents reviewed by Fox 26 Houston would later describe Zane's life as one punctuated by pain and intervention. The first signs came barely 10 days after his birth, when he was taken to the hospital with troubling injuries. Fractures to his arm, clavicle, and ribs. These were not the kinds of injuries that happen by accident, and certainly not to a newborn who could barely move on his own. The hospital staff flagged the case immediately. It was the beginning of state involvement. Child Protective Services, CPS, was called. By mid-July, a safety plan was in place. It restricted contact between Zane and his parents, especially his father. The plan stated that neither parent was allowed to be alone with the baby, and no overnight visits were permitted. Zane was to remain under the care and monitoring of a family member, his maternal great-grandmother. The intention behind the CPS order was clear: to shield a vulnerable infant from further harm. But whether the plan was strictly followed remains a serious question in the investigation. As the days passed, Zane lived inside the home on Main Street in Houston, where the court says both parents were still present at times. His fragile body bore the early signs of trauma that no baby should ever endure, and yet, the monitoring system designed to protect him wasn't enough. The layout of the apartment has not been fully detailed in public records, but it was from that home that the 911 call eventually came. It was in that home that his condition worsened on the evening of September 8th, and it was from that same home that emergency responders would carry him, barely alive, into the ambulance. Little is known about Zane's brief joys. There are no public photos showing his first moments swaddled in a hospital blanket, no shared videos of him smiling or being cradled. What we do know comes from medical files, injury reports, and official documents, none of which speak to his personality, only his pain. Still, even from the outside, one truth is undeniable: Zane was failed. Not just by individuals, but by a system that knew he was at risk and still couldn't keep him safe. A baby just weeks old, living under court supervision, and yet, on September 11th, he was declared dead from what the medical examiner called multiple blunt force injuries. As more information surfaced, many began asking not just who Zane was, but how this could happen to someone so small, so defenseless, especially when red flags were already on file. There are families in Harris County and beyond who are now haunted by what didn't happen in time. Missed check-ins, gaps in communication, a plan that looked strong on paper but failed to hold up in real life. And now all that's left is a timeline. 2 months, July 6th to September 11th. That was Zane's entire life. Should infant welfare checks be automatic after unexplained injuries, no matter what the parents claim? At just 10 days, doctors saw what no one wants to see. On July 16, 2024, a newborn baby named Zane Olston was rushed to a Houston area emergency room. He was just 10 days old. What the doctors found that day would change the course of his short life. According to medical records cited in court documents, Zane had multiple bone fractures, including his arm, ribs, and clavicle. These weren't birth injuries. They weren't the result of a fall or some accident. These were fractures that raised immediate, chilling concern. Doctors knew they had to act, and fast. Under Texas law, when a child comes in with injuries suspicious for abuse, the hospital must report it. That's exactly what they did. A report was filed with Child Protective Services, CPS, launching what would become a high-risk child welfare case. Zane, just days into life, became a baby under state watch. According to reporting from Fox 26 Houston, CPS immediately issued a safety plan. This plan was designed to keep Zane protected while investigators determined what had caused his injuries. But the plan didn't remove him from the home entirely. Instead, CPS assigned a monitor, his maternal great-grandmother, to supervise his care. The terms of the plan were clear: no overnight visits with either parent, no unsupervised contact. The parents, Deari Olston and Trinity Perez, were not allowed to be alone with their son. On paper, these rules seemed strict, but how strictly they were followed remains an open and deeply troubling question. The safety plan began July 16th and was initially set to expire July 31st. That's 2 weeks of supervision. After that, if no further concerns were raised, restrictions could be lifted or modified. Zane's case was no longer just about parenting. It became about compliance, monitoring, and trusting a fragile structure to hold up under pressure. Yet cracks began to show early. CPS relies heavily on family members to carry out monitoring. In this case, it was the great-grandmother likely doing the best she could. But unlike trained professionals, family monitors don't always recognize risk factors, and they aren't always equipped to intervene if something goes wrong behind closed doors. What's more, even though Zane had suffered serious physical injuries, he remained in the same environment where those injuries were suspected to have occurred. The individuals being restricted, his own parents, were still present in his life. That kind of gray area can become dangerous very quickly. Medical professionals who saw Zane's initial injuries believed they were non-accidental. The location of the fractures, the healing stages, the type of force required, all of it pointed to something deeply wrong. And yet, no criminal charges were filed at that time. No emergency removal took place. No arrest was made. Instead, Zane went back home. Under supervision, yes, but still inside a space that would eventually become a crime scene. Now, looking back, it's impossible not to ask, was this the moment he could have been saved? The July 16th ER visit was the first documented evidence that Zane's body had been harmed. He couldn't walk, couldn't roll over, could barely lift his head. Whatever happened to him had been inflicted by someone else. And even with the system's eyes briefly turned toward him, Zane didn't get out. 3 weeks later, those same systems would be called again, this time not for broken bones, but for something far worse. By then, it was too late. What safeguards should trigger after injuries like these, and should hospitals or CPS have the power to step in more forcefully without waiting? A monitor moves in. But did the plan actually protect him? Before we go further, make sure you're subscribed to this channel. These stories aren't easy, but they matter, and they deserve to be heard. Tap the bell so you don't miss what's coming next. In child protection work, the term safety plan is meant to provide reassurance, a structured response that allows an at-risk child to remain in familiar surroundings, while adults work behind the scenes to keep them safe. But in the case of Zane Olston, a 10-day-old newborn with fractures to his ribs, clavicle, and arm, the safety plan issued on July 16, 2024 may have done more to give the illusion of protection than real security. The Texas Department of Family and Protective Services, alerted by hospital staff after Zane was brought in for his injuries, quickly opened an investigation. A safety plan was implemented the same day. According to court records reported by Fox 26 Houston, the strategy was this. Zane would remain in the family's apartment. His maternal great-grandmother would act as a monitor. Both parents, Deari Olston, father, and Trinity Perez, mother, were allowed to see their son, but never alone. No overnight visits. All interactions had to be supervised. The plan was valid from July 16th to July 31st. That gave Zane 15 days of monitored care, with the assumption that if no new concerns emerged, the case might close or restrictions might ease. On paper, the model sounds cautious. But for an infant that young, especially one already documented as injured, many now argue it wasn't even close to enough. A great-grandmother serving as the monitor suggests a family trying to do the right thing. But this also reveals a systemic reality. CPS often turns to relatives rather than placing the child in foster care or protective custody, especially when they believe some level of family stability is present. Still, the burden placed on that monitor is heavy. It requires constant vigilance. It assumes full cooperation from the parents. It assumes the monitor will recognize subtle warning signs and report violations immediately, even if doing so could fracture family bonds. And there's no indication that professional caseworkers were present on a daily basis. Most safety plans rely on periodic check-ins, not constant oversight. In Zane's case, he was a newborn, unable to talk, cry for help, or even move with control. His life depended entirely on the actions and honesty of the adults around him. Court documents do not detail whether there were any reported violations during the July 16th to 31st period. But what they do show is that by early September, Zane was back in the ER, this time with a skull fracture, a brain bleed, and injuries that would ultimately claim his life. It's unclear whether the restrictions in the safety plan were still in place after July 31st, or if CPS allowed expanded parental access. Either way, it raises a question that now echoes across the case. Was this level of supervision ever truly enough? Medical experts say that once a baby shows signs of non-accidental trauma, the window to intervene is short. there's no guarantee of a second chance. In Zane's case, that second chance may have ended on July 31st, the day his protection plan expired. No court order, no criminal charges, just a return to status quo, with the hope that nothing else would go wrong. But something did go wrong, and 3 weeks later he was gone. Do you think this supervision model is enough for a newborn, especially one already injured? Or should the rules be stricter when abuse is suspected? Hit like, share the story, subscribe, and tap the bell. What happened to Zane must not be ignored. A second hospital, new injuries, a race against time. By the evening of Sunday, September 8, 2024, Zane Olston was only 64 days old. But in that short life, he had already endured more medical trauma than most people see in a lifetime. That night, he was rushed to the emergency room again, his second major hospital visit in just 2 months. The first time had been for fractures. This time, it was far worse. According to the charging documents cited by Fox 26 Houston, emergency personnel were called to the apartment where Zane lived, located at 1810 Main Street in Houston, Texas. The baby was unresponsive, and by the time he reached the hospital, his condition was critical. Medical staff immediately began examining him. What they found was devastating. Zane had suffered a skull fracture, which by itself can be life-threatening in a child so young. But the damage didn't stop there. He also had a subdural hematoma, a form of bleeding between the brain and the skull, indicating a significant traumatic injury. Worse still, doctors noted retinal hemorrhages in both eyes, which often point to violent shaking or blunt force trauma. These types of injuries are commonly seen in cases of abusive head trauma, sometimes referred to as shaken baby syndrome, though that term is used cautiously in legal settings. His tiny body had been battered in ways that doctors could not ignore. The hospital immediately flagged the injuries as suspicious. And the very next day, September 9th, a pediatric trauma consultation was requested. That meant Zane's case was no longer just a medical emergency. It was a potential criminal investigation. At this point, doctors weren't just treating him. They were documenting, taking scans, photographing injuries, filing formal reports to CPS and local law enforcement. Every bruise, every fracture, every internal bleed would now become a piece of evidence in what was shaping up to be a homicide case. But inside that hospital room, none of that mattered yet. What mattered was whether Zane could survive. Despite every effort by the trauma team, his brain activity began to diminish. Machines monitored his oxygen levels and vital signs. But as the hours passed, his neurological function continued to decline. By the following day, his condition was described as grave. The damage was irreversible. There was no way back. And while doctors fought to keep him alive, investigators began asking questions about the last 24 hours and what could have caused injuries this severe in a child who was already under CPS scrutiny. The timeline was chilling. Zane had already been seen by medical professionals for fractures back in July. A safety plan had been put in place. But now, just weeks later, he had returned with fresh trauma. Different injuries, far more lethal ones. This wasn't about an old wound healing poorly. These were new injuries, and the clock had run out. At the time of the ER intake, medical staff did what they always do in trauma cases. They stabilized his airway, monitored brain swelling, attempted to control the bleeding, but nothing worked. By September 9th, the trauma team understood Zane was likely brain dead, and yet they continued care, holding on to the smallest thread of hope. Over the next 2 days, tests were conducted to determine the extent of the brain damage. Monitors tracked any flicker of response. Family was notified. Social workers and caseworkers came and went. But in the end, it was clear. Zane was not going to recover. On September 11th, 2024, he was officially pronounced dead. He had never opened his eyes again after that ambulance ride. The trauma detailed in that final hospital stay became the cornerstone of what prosecutors would later call a capital murder case. But long before the legal labels were added, doctors already knew what they were looking at. One doctor reportedly wrote that the pattern of injuries was consistent with inflicted trauma. The skull fracture, the bleeding behind the eyes, and the fact that some of his ribs were in various stages of healing painted a horrifying picture, one that stretched over weeks. And it all came crashing down on September 8th. Which injury detail changed your view of what happened, the skull fracture, the brain bleed, or the retinal hemorrhages? Why does that one stand out most to you? Ribs in different stages of healing tell their own story. There are cases where the cause of death is immediate and clear. A wound, a weapon, a single tragic event. But in the death of Zane Olston, the autopsy didn't just explain what killed him. It revealed a timeline of repeated trauma. When the Harris County Institute of Forensic Sciences conducted the examination following Zane's death on September 11, 2024, their findings laid the groundwork for a homicide charge. This wasn't a case of sudden medical distress. It was a case of cumulative harm. The final autopsy report, cited in charging documents and reported by Fox 26 Houston, confirmed what many already feared. Zane died from multiple blunt force injuries to his head, torso, and extremities. Let's break that down. This included a skull fracture and internal brain bleeding. These injuries were among the newest and most severe, likely the cause of death. The brain is incredibly vulnerable in newborns. Even a single impact can lead to catastrophic swelling, hemorrhage, and permanent loss of brain function. In Zane's case, doctors had already noted neurological decline as early as September 9th, 2 days before his official death. By that point, he was showing no signs of brain activity, which was later confirmed during autopsy. This is where things became even more disturbing. The autopsy revealed that multiple ribs were fractured, but not all at once. Some were recent, with fresh breaks and bleeding around the bone. Others had partially healed, showing signs of older trauma. This detail matters immensely in cases like this. It suggests that Zane's injuries didn't happen in a single event. They happened over time. When investigators find injuries in various stages of healing, it often signals a pattern of abuse, not a one-time incident. The implication is chilling. Someone had harmed Zane more than once, and each time he had survived long enough to begin healing, only to be hurt again. In addition to the skull and rib fractures, Zane had injuries to other parts of his small body, including his arm and clavicle. These had first been documented back on July 16th, when he was just 10 days old. At the time, CPS had been notified, and a safety plan was put in place. Now, nearly 2 months later, the autopsy showed that some of those fractures were still healing, while others were new. It painted a heartbreaking picture. A baby whose body had been broken more than once, and who never had a chance to fully recover before the final blow. Here's what's important to understand. Multiple injuries in different stages of healing are almost never accidental in infants. A newborn does not have the strength or mobility to cause such harm to themselves. When multiple injuries exist, especially fractures, they are generally considered the result of inflicted trauma unless a clear and verified medical explanation is present. The autopsy didn't just describe Zane's injuries, charted them. Each fracture, each bruise, each hemorrhage added another layer to the story. A story where his body became the only witness. And that witness was loud. The skull fracture and brain bleed were likely the final assault. But the rib fractures, old and new, told investigators that this wasn't sudden. It was systemic. And it had likely been happening well before September. The findings were enough to elevate the case to capital murder, a charge reserved in Texas for the most serious of crimes, including the intentional killing of a child under the age of 10. But for the forensic team, this wasn't about charges. It was about truth. And the truth was written in every healed crack and every fresh break. How should investigators read injuries in different stages? And what do they owe victims like Zane when the signs are written across their body? Before the call for help, the internet had questions. One of the most chilling aspects of this case isn't just what happened to Zane Olston. It's what happened before anyone called for help. Investigators now believe the timeline leading up to the 911 call on September 8, 2024, contains one of the most telling pieces of evidence in the entire case: an internet search history. According to court records cited by Fox 26 Houston, someone inside the apartment, believed to be Zane's father, reached for his phone not to dial emergency services, but to ask Google what to do. The search history, later recovered from the father's device, includes phrases that prosecutors say were typed into the phone in the minutes before emergency services were contacted. These were not random or unrelated queries. They all pointed toward one terrifying reality. Something was wrong with the baby, and the adult in the room knew it. 3 o'clock, the timeline of a crisis. Authorities report that these searches were made before 911 was called, with a 39-minute gap between the first search and the actual emergency call. Here's what was reportedly searched. 2-month-old baby hard to wake up. What happens if your 2-month-old doesn't have a pulse? Does infant CPR really work? Will you go to jail if you find your child unresponsive? My 2-month-old died. Is anyone getting charged? Each of these searches was time-stamped, a digital footprint that prosecutors argue reflects a window of delay in seeking help. To them, this wasn't just someone panicking. It was someone calculating. Let's look at what each phrase might suggest. 2-month-old baby hard to wake up. This is often the first red flag in infant medical emergencies. Babies at that age typically wake easily, especially when hungry or uncomfortable. If a child becomes difficult to rouse, it can indicate serious neurological trauma, including brain swelling, oxygen deprivation, or concussion. By typing this into a search engine, the individual was already observing symptoms that should have prompted immediate medical attention. What happens if your 2-month-old doesn't have a pulse? This search is more direct and more alarming. It implies the individual had checked the baby and possibly could not find a pulse. That's a life-threatening situation in any age group, but in an infant, it means seconds matter. Instead of calling 911, the person paused to ask what would happen next. Does infant CPR really work? This question takes it one step further. It suggests an awareness that the baby might require resuscitation, and it reflects uncertainty, or perhaps doubt, about whether CPR is worth attempting. To medical professionals, this is unthinkable. You try. You always try. Will you go to jail if you find your child unresponsive? This is the first indication that the person wasn't just concerned for the child, they were concerned for themselves. It reveals a shift in focus from what the child needed to what might happen legally. And that shift is central to how investigators have interpreted this entire sequence of events. My 2-month-old died. Is anyone getting charged? This final search reads almost like a premonition. It's not a panicked plea for help. It's a question about consequences. And it appears to have been made before calling for medical assistance. According to law enforcement, the 39-minute delay between this digital activity and the 911 call is not just unusual. It's potentially incriminating. Brain what prosecutors believe it means. In court documents, the prosecution has suggested that these searches demonstrate consciousness of guilt. The idea that the person involved may have known what happened was wrong and wanted to avoid legal consequences. It's a common term in criminal law and is often used when defendants take steps to cover up, avoid, or delay reporting a crime. But the defense may argue something different, that the search history reflects panic, confusion, and a lack of understanding of what to do in a crisis. They may claim that the father didn't intend to hurt Zane and was simply overwhelmed. What makes this moment so difficult to interpret is that it could be both. Panic and guilt are not mutually exclusive. But from an investigative standpoint, what matters most is the delay. Zane was not breathing normally. He was unresponsive. His brain was swelling. And for nearly 40 minutes, no medical help was on the way. Instead, there were Google searches. And Zane, still alive at the time, was losing precious time. Do these searches point to panic, guilt, or something else entirely? And how much should a jury weigh digital evidence like this in a case involving a baby's death? 39 minutes. That's how long it reportedly took from the moment the first desperate search was typed into a phone to when someone finally dialed 911. Before we break that timeline down, make sure you're subscribed. These are stories that demand attention and accountability. Tap the bell, share this video, and let others hear what the evidence is really saying. The events of Sunday, September 8, 2024, are chilling on their own. But it's the 39-minute gap between private search history and public emergency response that may define the entire legal case. According to court filings and reports by Fox 26 Houston, investigators examining the death of 2-month-old Zane Olston uncovered a sequence of Google searches conducted by the child's father searches that began before any call for help was made. This sequence and the time that passed in between has become a major focus for both prosecutors and law enforcement. Let's walk through the critical details. Evening of September 8th. Zane is at home at the apartment on 1810 Main Street, Houston. Around 8 p.m., someone in the home opens a search browser. Over the next several minutes, the following phrases are typed, as recovered from the phone's data. 2-month-old baby hard to wake up. What happens if your 2-month-old doesn't have a pulse? Does infant CPR really work? Will you go to jail if you find your child unresponsive? My 2-month-old died. Is anyone getting charged? From the time the first search is made to the moment 911 is called, investigators estimate a gap of approximately 39 minutes. During that entire window, nearly 2/3 of an hour, no one contacted emergency services. In the field of emergency medicine, every minute matters, especially for infants. An unresponsive baby needs oxygen, needs circulation, needs trained medical care. Without those things, brain damage begins to occur rapidly. Survival depends on fast intervention, and every delay increases the chance of permanent injury or death. That's why, when investigators see a delay of 5 or 10 minutes, it's already a concern. But 39? That's not just hesitation. That's a decision to wait, a decision to search online instead of calling 911, a decision that may have cost Zane the only chance he had to live. For detectives, timeline gaps can be just as telling as physical evidence. They're the spaces where intent, fear, or concealment often hide. In Zane's case, prosecutors are reportedly using the 39-minute delay as evidence of what's known legally as consciousness of guilt. That term is used when someone acts in a way that suggests they know they've done something wrong and are trying to protect themselves instead of helping a victim. The idea is that someone who had caused harm, even accidentally, might search the consequences online before alerting authorities. And the more time passes, the more it suggests hesitation rather than instinct. But not everyone agrees. Defense attorneys may argue that this was a moment of panic, not premeditation, that the parent was scared, didn't know what to do, and froze. They might say the searches reflect confusion, not criminal thinking. That debate, guilt versus panic, is now at the heart of how this case may be argued in court. The truth is, digital forensics has changed everything. Investigators no longer have to rely on witness memory or speculation. Timestamps, GPS logs, app usage, these are hard facts. In this case, the searches weren't erased. In fact, some reports state the phone owner attempted to delete them, but they were later recovered through forensic tools. That may raise even more questions for a jury. Was the deletion an accident? Or another act of concealment? And above all, why wasn't 911 the first thing someone called? For those 39 minutes, Zane's condition was worsening. He wasn't breathing right. His brain was bleeding. His pulse, if it was present at all, was weakening. Every second mattered. And yet, Google got there first. What explanations could exist for a 39-minute delay before calling 911? And how do you think that delay should be weighed in a case like this? If this case moves you, share the story, subscribe, and hit the notification bell. Zane deserved a voice, and we will not let his memory fade. Capital murder and injury to a child, what those mean in Texas. When prosecutors filed formal charges in the death of Zane Olston, they didn't hesitate. The charges were not soft. They weren't reduced. They were among the most serious the Texas criminal justice system allows. According to court documents reviewed by Fox 26 Houston, the baby's father, 27-year-old Deari Olston, was charged with capital murder of a person under 10 years of age, one of the most severe charges under Texas law. The child's mother, 22-year-old Trinity Perez, was charged with injury to a child, serious bodily injury, which is also a felony offense with life-altering implications. But what do these charges actually mean? And how do Texas courts handle cases involving children, especially infants? Let's break it down clearly. In Texas, capital murder is defined under Texas Penal Code Section 19.03. While murder on its own is already a first-degree felony, punishable by 5 to 99 years or life in prison, Capital murder elevates the crime due to specific circumstances, making the penalties even more severe. Some of the factors that qualify a homicide as capital include killing a peace officer or firefighter in the line of duty, committing murder during another felony, such as kidnapping or sexual assault, committing murder for payment, murder for hire, murdering more than one person, murdering a child under 10 years old. Zane was 2 months old when he died. Because of his age, the charge meets the statutory threshold for capital murder. Capital murder is the only non-federal crime in Texas eligible for the death penalty. The punishment options are death by lethal injection or life in prison without the possibility of parole, LWOP. For adult defendants, there's no possibility of parole in capital cases, even if they're first-time offenders. In this case, Deari Olston, Zane's father, faces life without parole or execution if the district attorney chooses to pursue the death penalty. That decision hasn't yet been made public, and it often depends on various factors: intent, public interest, and strength of the evidence. Capital murder isn't about whether someone simply caused a death. It's about the circumstances surrounding it. Prosecutors allege Dane's death involved multiple blunt force injuries, previous trauma, and a delayed response, all contributing to the level of the charge. This is the charge filed against Trinity Perez, Zane's mother. Under Texas Penal Code Section 22.04, this offense applies when someone knowingly, intentionally, recklessly, or through criminal negligence causes serious bodily injury to a child, elderly, or disabled individual. Serious bodily injury includes injuries that create a substantial risk of death, cause permanent disfigurement, cause long-term loss of function, e.g. brain damage. This is a felony of the first degree, punishable by 5 to 99 years in prison or life, and fines of up to $10,000. While the father is accused of inflicting fatal trauma, the mother is being charged with failing to protect the child or possibly enabling the environment where the injuries occurred. In Texas, a parent can be criminally liable not just for what they do, but for what they fail to stop. This law recognizes that caregivers have a duty to intervene when a child is in danger, and failure to act can carry severe consequences. In Texas, the legal system treats crimes against children, especially very young ones, with profound seriousness. Infants are considered the most defenseless members of society. They can't run, can't speak, can't ask for help. As a result, the law gives prosecutors wide authority to pursue maximum penalties. Some observers believe the charges filed in this case send a strong message. Zane's life mattered. The bruises, fractures, and brain injuries weren't treated as tragic accidents. They were treated as criminal acts with full accountability. Others, however, will wait for the trial, because in any capital case, the stakes are enormous. Not just for the accused, but for the public, the families, and the legal system. The legal proceedings ahead will require a careful weighing of evidence, intent, neglect, and duty of care, all of which will unfold over months of hearings, expert testimony, and cross-examinations. Should penalties be different, stronger, or more flexible when the victim is an infant? Or is the current system striking the right balance between justice and due process? A story investigators say didn't fit the scans. After the second hospital visit, after the brain bleed, after the retinal hemorrhages and skull fracture, came the explanation. According to details reported by Law and Crime, Zane Olston's father, Deari Olston, allegedly told investigators that his son's deteriorating condition wasn't the result of trauma. He didn't mention blunt force. He didn't say the baby had fallen or been shaken. Instead, he allegedly offered a medical explanation. He claimed Zane may have suffered an allergic reaction. The assertion reportedly came during initial questioning after Zane had been taken to the hospital on September 8, 2024, with what doctors described as devastating internal injuries. At that point, the infant was unresponsive, and medical professionals were scrambling to save his life. The father's claim stood out, but to those treating Zane, and to the doctors reviewing his x-rays, brain scans, and CT images, the allergic reaction explanation simply didn't match what they were seeing. In a typical allergic reaction, especially in young babies, doctors look for signs like skin rashes or hives, swelling of the lips, eyes, or face, vomiting or diarrhea, trouble breathing, sometimes wheezing. In severe cases, anaphylaxis, a sudden, life-threatening reaction that involves airway constriction and blood pressure drops. But none of these symptoms were documented in Zane's case. Instead, hospital records and autopsy findings showed a skull fracture, subdural hematoma, bleeding between the brain and skull, retinal hemorrhages, multiple rib fractures, some in different stages of healing, other blunt force trauma injuries to the torso and limbs. To medical experts, that set of injuries isn't consistent with any known allergic reaction. In fact, it closely matches what emergency physicians often classify as non-accidental trauma, typically seen in abuse cases, particularly in infants and toddlers. Forensic pediatricians, who specialize in detecting signs of abuse in children, rely on decades of research, scans, and injury pattern recognition. When they see injuries that don't align with developmental ability, like a baby with a fractured rib who can't crawl or roll, their alarms go off. Retinal hemorrhages, in particular, are seen in less than 1% of accidental trauma cases but are common in abusive head trauma. They typically come from violent shaking or direct impact. In court filings cited by Fox 26 and Law and Crime, medical staff explicitly rejected the allergic reaction claim. Doctors noted that Zane's injuries were not the result of a medical condition or illness. They were inflicted. Despite that, under U.S. law, every defendant has the right to offer an explanation, mount a defense, and challenge the state's narrative. And at this early stage, what a person says to police, even if it's disputed by medical evidence, can still become part of the legal record. The defense may not ultimately stick with the allergic reaction theory. Could have been a panicked guess, a placeholder, or something said under stress. Defense attorneys may pivot to something else, like a fall, a medical emergency, or parental inexperience. But for now, it's one of the only public-facing explanations that's been recorded from the accused. This brings up a critical question. How should media and public platforms present defense claims that are medically or factually disputed? Ethically, media outlets are expected to report what the defense or suspect says clearly, contextualize those claims against established facts, avoid treating disputed claims as both sides if the evidence strongly contradicts them. Always specify that such claims are alleged or unconfirmed. Protect the presumption of innocence while still honoring factual reporting. In Zane's case, the allergic reaction explanation should be acknowledged, not erased, because it was reportedly offered by the father during questioning. But it must also be paired with what licensed doctors stated in response, which is that no medical signs supported that claim. If prosecutors choose to bring this claim up during trial, they may use it to demonstrate a possible attempt to mislead investigators, an effort to shift blame away from trauma, or even a sign of consciousness of guilt if the statement contradicts clear physical evidence. Meanwhile, the defense may argue it shows confusion, lack of medical understanding, or stress response, not intent to deceive. It's one more piece of a very complex puzzle. How should media and content creators like us handle early defense claims in a sensitive case, especially when medical professionals strongly disagree with those claims? When the state steps in, who watches the watchers? When 10-day-old Zane Olston was brought to the hospital on July 16, 2024, with multiple bone fractures to his arm, clavicle, and ribs, doctors immediately raised red flags, and rightfully so. According to reporting from Fox 26 Houston, the hospital contacted Child Protective Services, CPS, triggering a formal investigation into suspected child abuse. The agency acted swiftly, issuing what's known as a safety plan, a legal tool used in Texas and across the U.S. to keep children in their homes under increased oversight while avoiding full foster care removal. On the surface, it seemed like a protective step. Zane wouldn't be removed, but he would be closely monitored by a relative, his maternal great-grandmother, who was appointed by CPS as a family monitor. But today, that decision is at the center of serious questions, not just about what happened in that home, but about how the system is designed and whether it's equipped to protect children in real time. July 16, 2024. Zane is seen in the ER for unexplained fractures. CPS is notified. A safety plan is put in place the same day. Zane is allowed to remain in the apartment on Main Street under supervision. The parents, Deari Olston and Trinity Perez, are not allowed unsupervised contact and no overnight visits are permitted. The plan is set to last from July 16th to July 31st, 15 days of heightened oversight. After July 31st, it's unclear whether the safety restrictions were extended, lifted, or modified. But what is known is that Zane remained in the same environment, and on September 8th, he was back in the hospital, this time unresponsive, with a skull fracture and brain bleed. 3 days later, he died. Safety plans are not court orders. They are voluntary agreements between CPS and the family, often signed in moments of crisis. They are intended to be short-term, non-punitive measures to stabilize a household while the agency investigates. But here's the issue. Safety plans depend almost entirely on trust. Trust that the monitor will follow through. Trust that the parents will obey the restrictions. Trust that the environment won't shift once CPS steps back. In Zane's case, the maternal great-grandmother was likely doing her best. But she wasn't a trained caseworker. She wasn't equipped with the legal authority to intervene if the rules were violated. And CPS isn't inside the home 24/7 to verify compliance. What's more, after July 31st, there's no public indication that CPS continued frequent check-ins. The window between July 31st and September 8th is a gap of 39 days. A critical stretch where Zane's condition may have changed without anyone noticing. Supervised arrangements can fail in several key ways. Lack of training. Family monitors may not know how to recognize escalating abuse. Conflict of interest. Monitors are often emotionally connected to both the child and the parents. No enforcement mechanism. If parents violate the plan, monitors must choose whether to report them, which can strain family ties. Limited oversight. CPS caseworkers are stretched thin and may only visit occasionally. In high-risk cases like Zane's, where serious injuries had already occurred, should that kind of arrangement be considered enough? Some experts argue safety plans aren't appropriate when there's confirmed physical harm. Instead, they say immediate protective custody or foster placement should be considered. Others worry that such steps can traumatize families and should only be a last resort. The tragic reality is this: the system did step in. CPS was involved. And yet, Zane still died. This isn't about blame. It's about design. Was a 15-day supervision plan ever going to be enough for a baby who'd already suffered multiple fractures? Should family members be asked to enforce state protective rules without professional backup? Should the state allow infants to remain in any environment where injuries of unknown origin have occurred? These are the questions that Zane's death forces into the open, not just in Harris County, but everywhere. Because for every child like Zane who ends up in the headlines, there are many more in the shadows, waiting for the system to notice. What would you change about CPS monitoring rules in cases like this? Should safety plans be allowed at all when a baby has already been seriously hurt? Retinal hemorrhages and skull fractures, what they can indicate. Before we examine what the science says about Zane Olston's injuries, take a moment to subscribe, tap the bell, and share this video. These are difficult truths, but understanding them could help protect another child in the future. In child abuse cases, especially when the victim is too young to speak, forensic evidence becomes the loudest voice in the room. When 2-month-old Zane Olston was brought to a Houston hospital on September 8, 2024, he was unconscious, struggling to breathe, and suffering from injuries that stunned the trauma team. His scans, lab results, and physical examination painted a picture that would later become the foundation of a homicide investigation. According to autopsy findings and court documents cited by Fox 26 Houston, doctors and forensic specialists documented a set of injuries that are well known in pediatric forensics, and they mean something very specific. Let's break them down. One of the primary injuries listed in Zane's case was a fracture to the skull. This kind of injury in a 2-month-old is rare and deeply concerning. Infant skulls are more flexible than adult skulls. That's because their cranial bones are still forming and haven't fully fused. So to cause a skull fracture in a baby, significant force is usually required. far more than the result of a minor bump or routine handling. Skull fractures in infants are typically associated with direct impact to the head from dropping, hitting, or blunt trauma, acceleration-deceleration injuries, such as violent shaking combined with impact, crushing injuries, which are rare but possible in abuse cases. Doctors who reviewed Dane's CT scans and physical condition believed this fracture could not have been accidental, especially considering the surrounding injuries. A subdural hematoma is bleeding between the surface of the brain and the skull. In infants, this kind of internal bleeding most often comes from shaking, slamming, or forceful impact. It's one of the hallmark injuries in abusive head trauma, previously known as shaken baby syndrome. The shaking causes tiny blood vessels in the brain to tear, leading to bleeding, pressure buildup, and eventual brain damage or death if untreated. In Zane's case, the bleed was so severe that he was declared brain dead within 2 days of admission. Medical teams noted the lack of brain activity on September 9th, with death officially pronounced on September 11th. One of the most telling injuries found was retinal hemorrhaging, bleeding behind the eyes. These injuries are detected through a specialized eye exam, and in non-accidental trauma cases, they carry huge diagnostic weight. Retinal hemorrhages in infants are rare in accidental injuries, especially in the absence of high-speed car crashes, strongly associated with shaking or rotational head trauma, often bilateral, seen in both eyes, in abuse cases. According to court records, Zane had retinal hemorrhages in both eyes, which doctors stated were consistent with inflicted trauma. In plain terms, this kind of bleeding doesn't just happen, it's usually caused by force. Retinal hemorrhaging also helps investigators pinpoint the timing of abuse. Fresh bleeding versus partially healed vessels can give clues about when the trauma occurred, something that becomes critical in building a timeline. This finding was confirmed in the autopsy. Zane had multiple rib fractures, some new, some healing. That tells doctors this wasn't a single incident. He had been injured more than once. Rib fractures are particularly serious in infants because their ribs are flexible and don't break easily. Fractures often indicate squeezing or compression injuries. They're very painful and almost always result from outside force. In the absence of known accidents or a clear medical explanation, these injuries are considered highly suspicious for abuse. Medical experts follow a standardized forensic checklist: injury type and location, stage of healing, developmental ability of the child, i.e., can a 2-month-old roll off a couch, presence of multiple injury types, head plus ribs plus eyes, consistency of explanation from caregivers. In this case, the pattern told a tragic story. The injuries were inconsistent with normal infant activity and had no documented accidental cause. Doctors ruled out medical disorders, blood clotting issues, and bone fragility conditions. The final determination, non-accidental trauma, and ultimately homicide. Forensic doctors are not detectives. They don't name suspects or assign criminal intent. Their role is to interpret the injuries and describe what likely caused them, based on decades of data and clinical experience. In Zane's case, the physical evidence spoke clearly, and it matched none of the alternative explanations offered. Which forensic point was most clarifying for you, the brain bleed, the retinal hemorrhages, or the fractures in different healing stages? Why? If you believe stories like Zane's deserve to be heard, like, share, hit subscribe, tap the bell, and share this video with someone who cares. Phones don't just store messages, they store tone. In today's world, when someone is accused of a crime, investigators don't just ask where they were or what they did. They check what they typed, what they filmed, and how they said it. In the case of Zane Olston, what was found on a phone may carry just as much weight as what was found in an autopsy. According to information included in court documents and reported by Fox 26 Houston, law enforcement uncovered a number of digital files and messages on the phone belonging to Deari Olston, Zane's father. These files, texts, videos, and searches weren't just casual data. Prosecutors say they revealed patterns, attitudes, and tone that may support the charges filed. Let's break down what's been publicly reported so far and what it could mean. One of the more disturbing claims emerging from the court filings is that Olston allegedly recorded and shared videos of baby Zane crying and in distress, while making taunting remarks or inappropriate jokes in the background. These clips, according to prosecutors, were not meant as harmless moments or funny parenting snapshots. They are described in the documents as showing a lack of empathy, and in some cases, mocking or teasing behavior while the child appeared to be in discomfort. The public hasn't seen these videos and likely never will due to the child's privacy and the legal restrictions around such evidence. But their tone, content, and context are now part of the case. Investigators argue that these clips, combined with search history and medical findings, reflect a concerning attitude toward the baby and may indicate neglect or abuse even before Zane's final injuries occurred. It's worth emphasizing, the content of the videos has not been fully disclosed, and all characterizations are based on prosecutors' interpretations of what's on the device. The defense has not yet responded publicly to these claims, and the videos themselves have not been released or confirmed by independent media. Along with the videos, court filings describe text messages allegedly exchanged between Olston and Perez or other individuals that referenced Zane's behavior, crying, or parenting frustrations. In several messages, again, according to investigators, there were comments that prosecutors say suggested agitation toward the infant or joking references to the baby's crying or helplessness. In one reported exchange, there may have been texts suggesting difficulty handling Zane or allusions to getting him to quiet down. These messages are being examined not only for their literal content but for the emotional tone and context they reveal, whether the parents viewed Zane as a burden, a frustration, or worse. But here's the legal challenge. Tone in texts is subjective. One person's joke can be another's warning sign. A flippant comment may look dark in hindsight, especially after a tragedy. That's why defense attorneys often push back hard on the use of texts or videos as evidence of state of mind. In modern prosecutions, especially child abuse or neglect cases, digital evidence plays a growing role. Investigators look for patterns of frustration or aggression in communication, tone and language suggesting detachment or cruelty, recordings or photos that contradict what suspects told police, search history that may reflect prior incidents or knowledge of harm. But this raises ethical questions too. How much should courts infer from a video where someone sounds sarcastic? Is a parent venting privately the same as showing criminal intent? In Zane's case, the digital trail doesn't stand alone. It's being presented alongside autopsy findings, a delayed 911 call, prior CPS involvement, Google searches about death, CPR, and jail. The prosecution's theory is that these messages and videos show a consistent attitude that aligns with neglect, recklessness, or even malice. The defense will likely argue that tone is not proof of abuse, and that texts or jokes made in a moment of stress shouldn't be held up as evidence of intent to harm, especially when the actual cause of death is being contested. In Texas and elsewhere, courts have allowed digital communications to be entered as evidence, especially when they can be tied to timelines, behavior patterns, or contradictions in testimony. But tone alone rarely wins a case. The legal system still leans heavily on physical evidence, medical expert opinions, and clear timelines of events. That said, texts and videos can support or undermine credibility, and sometimes they tell a story that no witness ever could. For example, if someone claims they were concerned for a baby's health, but jokes about him crying in texts, or if a parent says they never noticed anything wrong, but searches for what happens if your baby dies, or if someone deletes videos showing distress, but the footage is recovered later, those digital footprints can shift a jury's perception quickly. How much weight should courts give to tone in videos or text messages, especially when the victim can't speak for themselves? The apartment sits on 1810 Main Street, Houston. On the outside, it looks like any other unit. Concrete, beige walls, a metal door, a few quiet neighbors coming and going. But behind that door, in a small, ordinary room, a baby boy took his final breaths. According to court documents, this was the last place Zane Olston was seen alive, and the first place investigators would return to with serious questions. When paramedics responded to the 911 call on the evening of September 8, 2024, they entered this apartment and found Zane unresponsive. He was just 2 months old, barely holding on. The injury list would later include a skull fracture, brain bleed, and retinal hemorrhaging. But here, inside this home, was where those injuries began. After Zane was rushed to the hospital, police sealed off the apartment. It became a crime scene. What happens next isn't shown in headlines. But every inch of that apartment became part of the investigation. Camera sound FX, soft clicks, photos were taken. Every room, every angle, notebooks filled with measurements. How far the couch was from the floor, where the crib sat if there was one. What surfaces were hard enough to cause a skull fracture. Whether there were signs of struggle or signs of silence. Nothing was assumed. Everything was questioned. In cases involving infant trauma, detectives are trained to look at everything. Is there evidence the child was left unattended? Are there signs of recent cleaning, maybe too recent? Any stains on the carpet? The furniture? Is the layout consistent with the caregiver's story? In this case, prosecutors say the story didn't match the scans. They believe the injuries weren't the result of a fall. They weren't caused by rough play or an accident with a bottle. They were caused by force. And the environment Zane was found in, that would either confirm or contradict what his parents later told police. Forensic teams likely examined baby blankets, pacifiers, pillows, and any hard objects nearby. They looked for blood traces, collected diapers, examined the baby's clothing. Digital devices were seized, 2 phones, likely belonging to both parents. And that's where the disturbing search history was found. 2-month-old baby hard to wake up. Does infant CPR really work? Will you go to jail if your child dies? Those searches weren't made at the hospital. They were made in that apartment before the 911 call. According to Fox 26 Houston, the delay between those searches and the emergency call was 39 minutes. 39 minutes. The apartment became more than just a location. It became the timeline's anchor point, the place where a child's life ended. Not suddenly, but quietly, behind closed doors. Where help came not first but late. Where silence wasn't just a sound, but a pattern. Investigators couldn't ask Zane what happened, so they listened to the walls, the layout, the absence of safety hazards, the phone on the table, the tone in the messages, and the injuries on his body. Sometimes the truth doesn't speak in words. It lives in rooms. If you were walking into that apartment as the lead detective, what's the first thing you'd look for, and why? Beat. From triage to ICU, the last 72 hours. When 2-month-old Zane Olston arrived at the hospital on the evening of September 8, 2024, doctors already knew this wasn't going to be a typical emergency room case. He was unresponsive. His breathing was shallow. He was showing no normal signs of alertness or responsiveness for an infant his age. Medical staff moved fast. They ordered scans and imaging, blood work, trauma protocol. Within minutes, the signs of severe internal injury began to emerge. A skull fracture, a brain bleed, retinal hemorrhaging behind both eyes. In that moment, Zane was still alive, but just barely. Doctors initiated immediate intervention. He was stabilized and transferred to a higher-level unit, likely intensive care, where machines began doing what his body could no longer manage on its own. He was connected to monitors tracking his heart rate, blood pressure, and oxygen levels. Tubes helped him breathe. He did not regain consciousness. According to Fox 26 Houston, the hospital requested a pediatric trauma consultation the very next morning, September 9, 2024, which is standard in suspected abuse cases involving infants. The involvement of a trauma specialist means the injuries were either worsening or considered too severe for the emergency team alone. By that time, Zane was showing no signs of brain activity. Medical staff began the process of confirming brain death, a grim diagnosis that follows careful neurological testing. This may have included EEG readings, pupil response checks, and clinical observation over time. In these cases, doctors usually hold multiple consultations, both to be thorough and to support the legal and ethical protocols that follow. Throughout September 9th and September 10th, Zane remained in the hospital under intensive care. There was no indication of improvement. He remained unresponsive, and no neurological recovery took place. Behind the scenes, child protection officials, hospital social workers, and law enforcement had likely been contacted. The reported injuries, a fractured skull, brain bleed, retinal hemorrhaging, and rib fractures, raised immediate red flags. And because Zane had already been treated for earlier injuries back on July 16th, his medical history was already on file with Child Protective Services. This was not a mystery illness. These were signs of inflicted trauma. By September 11, 2024, doctors declared Zane legally and medically dead. His short, painful life ended just 66 days after it began. That same day, Zane's body was transferred to the Harris County Medical Examiner's office. The autopsy findings confirmed what doctors had already suspected: multiple blunt force injuries, a skull fracture, subdural hemorrhaging, brain bleed, retinal hemorrhaging, rib fractures, some fresh and others already healing. The final cause of death: homicide. Here's a brief timeline based on available reports. September 8, 2024 evening. Zane is brought to the ER unresponsive. Imaging reveals skull fracture and brain bleeding. Retinal hemorrhaging is detected. CPR and emergency stabilization are performed. September 9, 2024 morning. A pediatric trauma specialist is called in. Zane is declared unresponsive with no brain activity. ICU care continues. Doctors begin evaluating for brain death. September 9th to 10th. Continued monitoring. No signs of improvement. Family is likely notified of grave prognosis. CPS and law enforcement deepen their involvement. September 11th, 2024. Zane is pronounced dead. He is transferred to the Harris County Medical Examiner for autopsy. Cause of death is later ruled homicide. This 72-hour period became the anchor of the criminal investigation. The timeline would later be contrasted with the 39-minute delay in calling 911, and with disturbing search history from the father's phone, searches that included questions like, "What happens if your 2-month-old doesn't have a pulse?" and "Will you go to jail if your baby dies?" But within the hospital walls, no one was thinking about charges. The only goal was survival, and even that proved impossible. Zane arrived too late. Where do you see the unanswered gaps in Zane's medical timeline? And what details do you believe should be made public in a case like this? 2 bonds, 2 charges, 1 county watching. When charges were formally filed against Deari Olston and Trinity Perez, the legal machinery of Harris County moved swiftly. Both faced serious accusations tied to the death of 2-month-old Zane Olston. And with those accusations came 2 different bond decisions, each one signaling how the court viewed their alleged roles. Deari Olston was charged with capital murder of a child under 10, one of the most severe criminal charges in Texas. His bond was set at $2 million. In contrast, Trinity Perez faced a charge of injury to a child causing serious bodily injury, and her bond was set at $250,000. While both amounts are significant, the disparity reflects the gravity and legal weight of each charge. Capital murder can carry penalties ranging from life imprisonment without parole to the death penalty in Texas, and courts treat it accordingly. The $2 million bond signaled that authorities viewed Olston as both a flight risk and a danger to the community, especially given the medical findings, timeline inconsistencies, and digital evidence already detailed in the case. Perez's bond, while lower, was still substantial. It likely reflected the state's concern about her alleged failure to protect Zane after earlier warning signs. Her charge, though not capital, is a first-degree felony, and the court likely considered the broader context. Past CPS involvement, prior ER visits, and her reported proximity to Zane during the crucial hours. After their arrests, both Olston and Perez were booked into the Harris County Jail. They had initial court appearances where charges were formally read, rights were explained, and procedural next steps were outlined. It's typical at this stage for defendants to plead not guilty, especially in serious felony cases where legal strategy requires time and full discovery. Legal representation also came into play. In capital cases, the state is required to appoint a specially qualified defense team if the defendant cannot afford private counsel. The same applies to Perez's charge. If indigent, she would be provided with a public defender. These lawyers begin reviewing evidence, requesting documents, and possibly filing early motions to suppress or challenge the state's case. At the heart of these proceedings is a simple but chilling fact. A 2-month-old baby is dead, and the people accused are his parents. With past CPS reports, a reported supervision plan, and now 2 formal felony charges, the public is watching closely. Bond hearings aren't about guilt or innocence, but they do offer a window into how seriously the court is treating the allegations. And in this case, Harris County isn't looking away. Do bond levels here feel proportionate to the charges? Or should they have been higher or lower based on the facts so far? If you believe Zane's story deserves justice, like, share, hit subscribe, and tap the bell. We'll follow this case to the end. The death of Zane Olston has raised complex legal and moral questions, not just about what happened, but about what should have happened. At the center of these conversations is the law in Texas surrounding injury to a child, particularly when it involves a caregiver who may not have directly caused harm but allegedly failed to prevent it. In Texas, the statute covering injury to a child is found under Section 22.04 of the Texas Penal Code. It is one of the most serious charges a person can face, and it does not apply only to someone who directly causes harm. The law also holds individuals criminally responsible if, through omission, they allow serious injury to occur, especially if they are considered a caregiver or have a legal duty to act. This is why Trinity Perez, Zane's mother, is facing a charge of injury to a child causing serious bodily injury, even though the capital murder charge is directed at Deari Olston. Prosecutors allege that her responsibility wasn't just passive presence. It was her failure to act, to intervene, or to seek timely medical attention that formed the basis of the case against her. According to Texas law, an omission becomes criminal when the person has a legal duty to act. In the case of a parent or legal guardian, that duty is assumed. If a child shows visible injuries, unusual behavior, or signs of distress, and the parent does nothing, the law may interpret that as willful neglect, especially if medical help could have prevented the outcome. But not every failure to act is automatically criminal. Courts are instructed to look at the circumstances, knowledge, and intent. Did the caregiver know something was wrong? Were there earlier warnings? Was help delayed or denied intentionally? Or was there confusion or panic? These questions matter, and juries must wrestle with them when deciding guilt. In Zane's case, the reported 10-day-old ER visit triggered a CPS safety plan. That detail alone may strengthen the prosecution's position that the mother was aware of prior injuries. The autopsy suggesting rib fractures in multiple stages of healing also points to ongoing harm, not a single incident. And the reported 39-minute delay before calling for help on September 8th is now a critical point in the narrative, one the court will likely scrutinize closely. Still, Texas courts are cautious. Charges rooted in failure to protect must be proven beyond reasonable doubt. That means showing not just that a child died or suffered, but that the caregiver was consciously indifferent to the danger. It is not enough to simply prove the parent was there. Prosecutors must show they knew something was wrong and chose not to act. These laws exist to protect the most vulnerable, but they also challenge courts to draw difficult lines. In cases involving infants who cannot speak, cannot walk, and cannot explain what happened, the evidence must often come from patterns. Medical charts, texts, past hospital visits, and timelines. Piecing it together requires patience, expertise, and restraint. What makes Zane's case so difficult, so emotionally charged, is that it touches all the fault lines. Parental duty, medical complexity, past intervention, and tragic finality. Whether the charges lead to conviction is for the courts to decide. But the law on failing to protect ensures that the question will be asked and answered in full. How should the law balance intent versus failure to act, especially when a child can't speak for themselves? A baby's name trends. What should responsible coverage look like? As details of Zane Olston's case continue to unfold, the public reaction has been swift and impassioned. From neighborhood discussions in Harris County to national threads on social platforms, a wave of emotion, grief, rage, disbelief has followed every new headline. Dane's name, just 2 months old, has already become a symbol of a much broader conversation. Local media outlets like Fox 26 Houston have played a central role in shaping that narrative. From the earliest reports of Zane's arrival at the ER on September 8th, to court filings that revealed the capital murder and injury charges, the station has provided factual, sourced reporting. Still, even straightforward coverage can create ripples that grow into storms online. And with stories involving infants where vulnerability is absolute, the ethical boundaries of media responsibility become harder to ignore. One of the most critical questions is how a child's image and identity are handled. Zane was just a newborn. In some reports, his photograph has circulated, tiny, wrapped in a hospital blanket. But who decides when it's appropriate to share an image of a child who cannot consent? And when that child has died, what does respectful remembrance look like in a media culture driven by engagement metrics and viral headlines? There's also the issue of tone. Some creators and commentators lean into sensationalism, presenting speculation as fact, or overlaying emotionally charged music and dramatic narration to elicit outrage. Others attempt to inject personal opinions into stories that are still under active investigation, sometimes misrepresenting court filings or misquoting medical terminology. Even when unintentional, this can spread misinformation fast, and unlike in traditional journalism, there is no editorial process for many online creators. In contrast, responsible media platforms and YouTube creators must take extra care. That means sticking to verified facts from primary sources, court documents, police statements, credible news reporting, and resisting the urge to fill in the blanks with guesses or assumptions. It means protecting the privacy of family members who are not part of the case, and not republishing rumors or unverified claims that circulate on social media. In this channel, we take those responsibilities seriously. We name only what has been publicly released through verified outlets. We avoid showing crime scene images, leaked footage, or speculative witness interviews unless they've been confirmed through multiple sources. And when allegations are presented, we clearly label them as such, allegations, not verdicts. This also means acknowledging what we don't know. Not every medical detail, timeline point, or legal rationale has been released. That's not a flaw in the reporting. It's part of the process. Trials take time. Investigations proceed in silence. And sometimes, families are grieving in private. The need for updates doesn't outweigh their right to space. In the wake of Zane's death, the community response has reflected a deep yearning for justice, but also a desire to understand how the system failed. Conversations about CPS oversight, ER protocol, and parental accountability are necessary. But so is caution, especially when emotions run high and the accused are still awaiting trial. For those of us documenting the case, it's about more than clicks. It's about the life of a child, brief, bright, and ended far too soon. Zane deserves dignity in death, just as he deserved protection in life. And it's on all of us, creators, reporters, and viewers, to make sure that dignity is preserved. What do you expect from creators and media outlets when they cover cases involving infants? Indictment, discovery, expert reports, the slow part begins. After the initial waves of public outrage and legal filings, a quieter, more deliberate phase begins. The legal machinery turns at its own pace. In the case of Zane Olston, now charged as a capital murder and injury to a child case, the procedural road ahead is measured not in hours or even weeks, but in months, sometimes years. First, there's the formal indictment, which typically follows preliminary charges filed by police and reviewed by prosecutors. While both parents were arrested in September, it's the grand jury that will determine whether sufficient probable cause exists to formally pursue each charge. In Harris County, grand juries are seated regularly, and in high-profile cases like this, indictments often come swiftly, but there's still a crucial step. Once indicted, discovery begins. This is the process where prosecutors and defense attorneys exchange the evidence they intend to present. In a medical death case involving an infant, discovery can be vast and highly technical. Prosecutors will rely on hospital charts, autopsy records, trauma assessments, CPS documentation, interview transcripts, body cam footage from first responders, and digital data like internet searches or text messages. Defense attorneys, meanwhile, will be looking closely at that same evidence for inconsistencies, alternative explanations, or potential procedural errors. expert testimony will play a central role. It's not just about what happened to Zane, but when and how. Pediatric forensic pathologists will be consulted to interpret the stages of healing on fractures. Neurologists might be called in to discuss brain bleeds and what timing can be inferred. Ophthalmologists may be asked to explain retinal hemorrhages, commonly cited in shaken baby cases, but also subject to ongoing debate in medical legal circles. The defense may retain its own set of experts to challenge or provide alternative interpretations of the state's findings. Competing medical opinions are not uncommon in child injury or death trials, and they can be persuasive to a jury, especially if the science itself is complex, evolving, or not widely understood. Then come pretrial motions. These filings shape the legal battlefield before trial. Motions to suppress evidence, to limit expert testimony, to change venue due to publicity, or even to sever the trials of the two parents. All are on the table. Attorneys may ask to exclude certain text messages, delay proceedings to allow more expert review, or request bond reconsiderations. Meanwhile, the calendar fills up slowly. Court dates are set for check-ins, status conferences, and procedural hearings. Each side requests more time to consult experts or gather evidence. Months pass between hearings. The public often grows frustrated with this pace, but in capital cases, where the stakes are life imprisonment or potentially the death penalty, the system is designed to move carefully. Due process requires it. As of now, no trial date has been publicly announced. That's not unusual. Prosecutors may still be finalizing expert lists and forensic exhibits. Defense teams are likely conducting their own analysis. A judge will eventually set the timeline for readiness, but extensions are common, particularly in Harris County, where the court backlog remains substantial after the pandemic. Even high-profile cases move incrementally. While the headlines have faded slightly, inside courtrooms and legal offices, the case is far from over. What comes next won't be dramatic. There won't be sirens or breaking news. It will be documents filed, evidence examined, experts interviewed. It will be silent hearings and slow steps. For those seeking justice for Zane Olston, this is the part that demands patience and faith that the system, though imperfect, is still grinding forward. Which expert testimony do you think will matter most in determining how this case unfolds? Beyond the filings, a short life that should have been protected. Zane Olston never got to take his first steps, never said his first words. He lived just over 9 weeks, born July 6, 2024, and declared dead on September 11th. What happened in between now sits inside court documents, autopsy reports, and legal motions. But beyond the clinical language and the headlines, there was a real child, a newborn whose life unfolded in days, not years. The timeline is tragically short and sharply documented. At just 10 days old, Zane was taken to the hospital on July 16th with unexplained fractures. Doctors saw signs of blunt force trauma. Child Protective Services stepped in. A safety plan was put in place. No overnights with the parents, supervised visits only, monitored by a maternal great-grandmother. But just weeks later, on September 8th, Zane was rushed to a different hospital. This time, the injuries were more severe. Skull fractures, retinal hemorrhages, bleeding around the brain. Doctors declared him in critical condition. The next few days were a blur of scans, treatments, and urgent care decisions. Despite everything, Zane's condition worsened. He was pronounced dead on September 11th. Forensic analysis later revealed multiple injuries in various stages of healing, raising troubling questions about how long the trauma had occurred and whether any opportunities to intervene had been missed. CPS involvement had already begun after the first hospital visit. A monitor had been placed in the home, but something failed. Somewhere between policy and people, a gap opened and Zane fell through it. The legal system will take its course. Prosecutors will present evidence. Defense attorneys will argue their case. But no matter the outcome, nothing brings Zane back. And that's why remembering him matters. Not just as a case file, not just as a name in the news, but as a reminder of what child protection is supposed to mean, of the importance of early intervention, clear oversight, and unflinching attention to red flags. Because children can't report abuse. Infants can't defend themselves. They rely on adults, family, neighbors, medical staff, CPS workers to act when something is wrong. If there's any purpose in recounting what happened to Zane, it's this: to make sure the same mistakes aren't repeated. There are resources for those who want to help or learn more. Texas Department of Family and Protective Services. Prevent Child Abuse America. Child Help National Child Abuse Hotline. 1-800-4 A Child. Zane deserved more. He deserved protection, peace, and a future. Now all that remains is memory and a responsibility to do better. What policy change would you support to prevent cases like this from happening again? In loving memory of Zane Olston, you were only here for a moment, little star, but in that moment you shined. You never got to grow, to play, to speak your first words, but your presence was real and your absence is felt. You didn't get to choose your story, but we will remember you with tenderness, not tragedy, not as a headline, not as a case number, but as a boy who should have been safe, a child whose life should have been filled with lullabies, not autopsies. Zane, you mattered, and we will not let the world forget that. Forever in our hearts, baby boy, for Zane, for every child who needed protecting. If this story moved you, please like, share, subscribe, and hit the notification bell to follow more real cases with clarity, care, and verified facts.